Assalamualaikum, my name is Natasha binti Muhammad Nizam.
Assalamualaikum, my name is Adeeba Annastasia binti Muhammad Azrin.
Assalamualaikum warahmatullahi wabarakatuh. My name is Aida binti Yusmarfarid.
Hi, Assalamualaikum. My name is Adlyn Safiah binti Samah.
My name is Aisha Hana binti Ezmel.
Malaysia practice a constitutional democracy system where the federal constitution serves as the highest law of the country. As such, all branches of government are required to exercise their powers in accordance with the constitution. The federal constitution guarantees several fundamental liberties, including the right to freedoms of speech and expression, freedom of peaceful assembly, personal liberty and equality before the law. Although these rights are not absolute, any restriction imposed by the government must be lawful, reasonable and proportionate. In this case, the dispute arises from action taken by Guru, which is the Prime Minister, under the National Security Council Act 2016. Guru declared the entire country a security area, imposed a nationwide curfew, ordered the freezing and removal of social media accounts, and later arrested and prosecuted Gagah and Gigih for sedition. Gagah and Gigih argued that these actions are unconstitutional and amount to unjustified infringement of their fundamental liberties. They further contend that the Nationwide Security Declaration effectively bypassed the constitutional emergency framework under Article 150 and represent an excessive exercise of executive power.
Assalamualaikum, my name is Natasha and I will be presenting on the first issue, which is whether the Prime Minister's declaration of the entire country as a security area and the subsequent nationwide curfew under the National Security Council Act 2016 is ultra-vires the Federal Constitution. To answer this issue, let us look at the statutory conflict. Under Section 18 Clause 1 of the NSC Act 2016, it allows the Prime Minister to declare a specific location as a security area. Once triggered, it unlocks sweeping quasi-emergency powers like curfews. However, under Article 150 Clause 1 of the Federal Constitution, the exclusive supreme prerogative to proclaim an emergency is vested solely in the Yang di-Pertuan Agong. By declaring the entire geography of Malaysia as a security area simultaneously, the Prime Minister bypassed this constitutional limitation. Under Article 4, Clause 1, the Constitution is supreme. An ordinary act of Parliament cannot be used to usurp a constitutional mechanism. This violates the doctrine of colourable legislation, which states that executive cannot use a statutory tool to do indirectly what the Constitution bars them from doing directly. Now, the Prime Minister might argue that national security is non-justiciable. He might even rely on the federal court ruling in the case of Stephen Kaluningkan and Government of Malaysia 1968, which held that emergency proclamations are subjective executive decisions. However, this argument fails on two grounds. First, Stephen Kaluningkan case involved a formal Article 150 emergency proclamation, whereas the Prime Minister is merely exercising statutory discretion under ordinary law. Second, on appeal to the Privy Council in 1968, their lordships clarified that even emergency determinations are judicially reviewable if they are product of gross bad faith or entirely lack a factual foundation. Additionally, because this is an exercise of statutory discretion, it is never absolute. In Muhammad Azam bin Muhammad Noor and Ketua Polis Negara 2002, the Federal Court held that statutory security powers are subject to an objective test. The judiciary has both the power and the duty to examine the factual grounds of executive action to ensure it isn't a political stunt, must in national security language. The facts in this case show zero objective threats to national security. The Prime Minister in this case acted out of pure panic over his declining popularity to freeze dissent and cover up his corruption. This brings up the landmark case of Sri Lanka Enterprise 1979. As Raja Azlan Shah famously stated, every legal power must have legal limits, otherwise there is dictatorship. A statutory authority cannot use its power for a collateral purpose unvouched by the statute. Using national security legislation for political self-preservation is the very definition of collateral purpose, therefore rendering the decision void. Finally, the unconstitutional nature of the unilateral power in the 2016 Act as exercised by the Prime Minister is so severe that the Parliament subsequently passed the NSC Amendment Act 2020. This amendment stripped the Prime Minister of this unilateral power and rightfully retained the authority to declare security areas to the YDPA, aligning it with Article 150 Clause 1. In conclusion, because the Prime Minister acted with malafide for a collateral political purpose, failed the objective standard, and usurped the royal prerogative under Article 150 Clause 1, his nationwide order and curfew are completely ultra-vires and unconstitutional. As such, they are null, void, and of no legal effect. Finally, the unconstitutional nature of the unilateral power in the 2016 Act as exercised by the Prime Minister is so severe that the Parliament subsequently passed the NSC Amendment Act 2020. This amendment stripped the Prime Minister of this unilateral power and rightfully retained the authority to declare security areas to the YDPA, aligning it with Article 150 Clause 1. In conclusion, because the Prime Minister acted with malafide for a collateral political purpose, failed the objective standard, and usurped the royal prerogative under Article 150 Clause 1, his nationwide order and curfew are completely ultra-vires and unconstitutional. As such, they are null, void, and of no legal effect.
So moving on to the second issue, whether the nationwide curfew imposed pursuant to the declaration of a security area under the National Security Council Act 2016 unlawfully restrict the constitutional right of Gagah, Gigih and other citizens to assemble peacefully as guaranteed under Article 10 Clause 1 Clause B. The first relevant constitutional provision here is Article 10 Clause 1 Clause B of the Federal Constitution. This provision guarantees every citizen the right to assemble peacefully and without arms. The purpose of this right is to allow citizens to gather collectively and express their views, opinions and concerns on matters affecting the nation. In the present case, Gigih merely proposed a rally in support of Gagah. However, the right to peacefully peacefully assembly is not absolute. Article 10 Clause 2 Clause B allows Parliament to impose restriction on this right where it is necessary in the interest of the security of the Federation or public order. This provision is important because Guru attempted to justify the nationwide curfew on the basis of national security and public order. Therefore, the issue is not simply whether the rally is protected under Article 10 Clause 1 Clause B, but whether the restriction imposed by Guru can be justified under Article 10 Clause 2 Clause B. In other words, we must determine whether the curfew was genuinely imposed to address a legitimate security concern or whether it was merely used as a means to suppress criticism and prevent citizens from exercising their constitutional right to assemble. Accordingly, in determining whether the nationwide curfew is constitutional, it is important to consider whether it was genuinely imposed for national security or public order purposes, or whether it was instead used as a way to suppress public criticism and prevent the exercise of the right to peaceful assembly. The principle on restriction under Article 10 were clarified in Nik Nazmi bin Nik Ahmad and Public Prosecutor. In that case, the Court of Appeal held that although Article 10 Clause 2 Clause B allows Parliament to impose restriction in the interest of security and public order, such restrictions are not automatically valid just because they are enacted by law. Instead, the Court emphasized that any restriction must be reasonable and proportionate, and there must be a rational connection between the restriction and the objective it seeks to achieve. Applying this principle, the Court upheld the 10-day notice requirement under Section 9, Clause 1 as a valid regulatory measure. However, it struck down Section 9, Clause 5 because criminalizing the failure to give notice was considered disproportionate to legislative objective. Overall, Nik Nazmi establishes that although the right to peaceful assembly is not absolute, any restriction must satisfy the requirement of reasonable and proportionality. If a restriction goes beyond what is necessary, it may be declared unconstitutional under Article 10, Clause 1, Clause B. Applying the principle in Nik Nazmi to the present facts, the nationwide curfew imposed by Guru, the Prime Minister, constituted a substantial interference with the constitutional right of Gaga, Gigih and other citizens to assemble peacefully under Article 10, Clause 1, Clause B. From the facts, Gigih merely suggested a rally in support of Gaga after he was accused of plotting against the government. There is no indication that the proposed rally was violent, armed or posed any threat to public order. Instead, it appears to be a peaceful gathering for citizens to express support and raise concerns about government conduct. Therefore, it falls within the protection of Article 10, Clause 1, Clause B. Although Guru may rely on national security and public order under Article 10, Clause 2, Clause B, the restriction must still be reasonable and proportionate as stated in Nik Nazmi. While public order is a legitimate objective, the measure taken appear excessive. Instead of less restrictive measures such as regulating the time, place or manner of the rally, Guru imposed a nationwide curfew by declaring the entire country a security area. This prevented the rally and significantly restricted the right to assemble. Even though only one peaceful rally was planned, the restriction therefore appears disproportionate. Furthermore, the facts suggest the curfew may have been influenced by declining public support and criticism of corruption and abuse of power, raising doubt as to whether it was purely for public order. Therefore, applying Nik Nazmi, there are strong grounds to argue that the curfew is disproportionate and fails to meet the requirement of reasonable under Article 10, Clause 1, Clause B. This conclusion is further supported by the decision in Siva Rasa Rahsia and Badan Peguam Malaysia and another. In this case, the Federal Court dealt with a restriction under Section 46A of the Legal Profession Act 1976, which limited certain lawyers holding a political position from serving in the Bar Council. Although the case mainly concerned freedom of association, the court laid down an important constitutional principle, which is that any restriction on fundamental liberties must satisfy the doctrine of proportionality. This means that first, the objective of the restriction must be sufficiently important. Second, the measure used must be rationally connected to the objective. And third, the restriction must not go beyond what is necessary to achieve the objective. The court also clarified that this proportionality requirement does not only apply to legislation passed by Parliament, but also to executive and administrative actions by the government. In this way, Siva Rasa Rahsia reinforces the principle established in Nik Nazmi, especially that even executive actions, such as the nationwide curfew imposed in this case, must still comply with constitutional requirements of reasonableness and proportionality. Applying the principle from Siva Rasa Rahsia, Guru's decision to impose a national curfew appears to fail the proportionality requirement. Although the protection of public order and national security may be considered legitimate objective, the measure taken in this case seemed excessive in the circumstances. From the facts, Gigih merely suggested a peaceful rally in support of Gaga, and Gaga later shared the post. There is no indication of violence, armed resistance, or any real threat to national security. Therefore, it is questionable whether a nationwide curfew is rationally connected to the prevention of single peaceful assembly. Instead of targeted regulation, Guru imposed a nationwide curfew affecting all citizens across the Federation. However, less restrictive alternatives such as regulating the time, place, or manner of the rally were available. This shows that the restriction may not satisfy the requirement of minimal impairment as it goes further than what is necessary to achieve the stated objective. More importantly, the surrounding facts suggest that Guru acted in response to declining public support and increasing criticism of a corruption allegation. This raises doubt as to whether the curfew was genuinely imposed for public order or national security purposes or instead to suppress political opposition. As emphasized in Siva Rasa, any restriction that is excessive or used as a pretext to limit constitutional right cannot be justified. Therefore, the nationwide curfew is arguably disproportionate and unconstitutional under Article 10, Clause 1, Clause B. Therefore, applying both Nik Nazmi and Siva Rasa, Gaga and Gigih have strong grounds to argue that the nationwide curfew is a disproportionate and unconstitutional restriction under Article 10, Clause 1, Clause B. This is because the curfew goes beyond what is reasonably necessary in the circumstances, as less restrictive measure could have been used instead. In addition, the justification given in terms of public order and nationality security appears weak, given that the planned rally was peaceful in nature. Overall, the curfew affects the right to peaceful assembly in an excessive manner, and therefore it is likely to be unconstitutional under Article 10, Clause 1, Clause.
So now let's move on to the third issue, which is whether the executive order issued by the Prime Minister to immediately take down and freeze the social media accounts of Gaga and Gigih unconstitutionally infringes upon their right to freedom of speech and expression guaranteed under Article 10, Clause 1, Clause A of the Federal Constitution. And Clause 1A of the Federal Constitution, the law explicitly guarantees that every citizen has the right to freedom of speech and expression. Although the Federal Constitution does not define the term expression, it has been interpreted broadly to encompass various forms of communication beyond spoken words. Therefore, freedom of expression includes the dissemination of ideas through signs, videos, advertisements, and other modern forms of communication. Accordingly, social media posts may constitute a recognized form of expression falling within the protection of Article 10 Clause 1A, as they enable individuals to share and disseminate information and their opinions through the digital platforms. Even so, the right is not absolute. In Article 10 Clause 2A, it permits Parliament to impose restrictions on freedom of speech in the interest of national security, friendly relations with other countries, public order, or morality. Nevertheless, such restrictions remain subject to constitutional scrutiny as provided by Article 4 Clause 2B of the Federal Constitution. This principle is illustrated in the case of Muhammad Hilman bin Idham and Kerajaan Malaysia 2011. In this case, the university students faced disciplinary proceedings under Section 15, Subsection 5, Paragraph A of UUCA for expressing support for a political party during an election campaign. Consequently, the Court of Appeal in this case held that the provision was unconstitutional as it imposed an unreasonable restriction on freedom of expression. The principle that can be derived here is that the restrictions under Article 10 Clause 2A must be reasonable and bear a rational connection between the speech being restricted and the preservation of public order or morality. Therefore, if there is no genuine threat to public order, restrictions should not extend beyond what is reasonably necessary. Now, let's apply the law to the present facts where Gagah and Gigeh may argue that the freezing and takedown of their social media accounts violates their right to freedom of speech and expression under Article 10 Clause 1A. As established earlier, social media posts constitute a recognized form of expression and therefore fall within the constitutional protection. Although Article 10 Clause 2A permits restriction on this right, such restrictions must be imposed by Parliament through enacting law. However, as we can see in the facts, it indicates that the restriction was imposed directly by Guru, who is the Prime Minister, through an executive order rather than pursuant to any specific legislation enacted by the Parliament. Consequently, it may be argued that Guru had acted beyond the constitutional framework governing restrictions on freedom of speech and expression under Article 10 Clause 1A. Moreover, Guru's contention that the post threatened public order may not be legally sustainable. In determining whether such a restriction can be justified under Article 10 Clause 2A, it is necessary to consider whether the contents of Gagah and Gigeh's posts are capable of constituting seditious expression. If the posts do not possess a seditious tendency, Guru's claim that they threaten public order may become significantly weaker. Let's take a look at the principle in the case of Kerajaan Malaysia and Mat Syuhaimi bin Syafi'i, 2018, where the Federal Court explained that although intention is generally irrelevant in determining a seditious tendency under Section 3, Subsection 3 of the Sedition Act 1948, expressions falling within the exceptions under Section 3, Subsection 2 remain protected. In particular, Section 3, Subsection 2B provides that a statement is not seditious if it points out errors or defects in the government with a view to remedying them. Looking at the facts of the scenario, Gagah merely advised Guru against corruption and cronyism, while Gigeh clarified that such criticism was intended for the betterment of the nation. Their statements sought only to highlight Guru's misconduct and encourage governmental reform rather than to incite hatred to cause public disorder. Furthermore, the post did not contain any remarks capable of promoting hostility or ill will between different races, classes, or groups within society. Instead, they were directed solely at criticizing the conduct of the Prime Minister and his administration. Accordingly, their expressions undeniably fall within the protection provided under Section 3, Subsection 2, Paragraph B of the Sedition Act 1948 because the statements made only to point out the errors or defects in the government with a view to remedying them. This significantly weakens Guru's reliance on public order as a justification for restricting their freedom of expression. In conclusion, the executive order issued by Guru is likely unconstitutional. The restriction was imposed through an executive procedure rather than a law enacted by Parliament as required under Article 10 Clause 2A, and Guru's reliance on public order is weakened by the fact that Gagah and Gigeh's statement undeniably fall within the protection of Section 3, Subsection 2, Paragraph B of the Sedition Act. In addition, the complete freezing and removal of their social media accounts was disproportionate as it went beyond what was reasonably necessary to address any alleged threat to public order. Ultimately, the executive order constitutes an interference with the right to freedom of speech and expression guaranteed under Article 10 Clause 1A of the Federal Constitution.
The fourth issue is whether the sedition prosecution against Gagah and Gigeh constitutes a mala fide and selective prosecution, thereby violating Article 8 Clause 1 and resulting in a deprivation of personal liberty, otherwise than in accordance with law under Article 5 Clause 1. So first of all, we need to look at Article 5 Clause 1 of the Federal Constitution. So in this article, it has been mentioned that no person shall be deprived of his personal liberty save in accordance with law. So law here refers to the word lex or jus. Lex means that a law is valid even if it's immoral or unequal, and jus means that the law passed must be in line with the principle of natural justice. So in the case of Ong Achuan NPP, it has been defined the word law to jus, where it must conform to the principle of natural justice, which is audi alteram partem, rights to be heard, and nemo judex in causa sua, rights against bias. Thus, a person's right to life and personal liberty can be limited with principles of natural justice. These rights can only be taken away provided if it's done legally, such as through lawful arrest. So, what are the grounds for unlawful arrest? One of it is mala fide. So, under Article 5, Clause 2 of the Federal Constitution, it has been mentioned if a person is arrested under unlawful arrest, they can apply for habeas corpus. So in the case of Menteri Hal Ehwal Dalam Negeri and Kapal Sings, it has been mentioned that honest mistakes, bad evidence or completely false allegations by the government do not constitute mala fide. So in this case, even though Kapal Sings proved he was not present, the court ruled that this was a matter of the sufficiency of facts. Thus, to establish mala fide in this context, the detainee cannot just show that the government was wrong, the detainee must prove personal malice or an ulterior improper motive, such as the minister detaining someone purely to settle a personal score or to eliminate a political rival while knowing full well that the person is innocent. Now, let us look into Article 8, Clause 1 of the Federal Constitution, where it guarantees equality before the law and equal protection of the law. So, equality means equal justice. Persons in similar circumstances should be treated similarly, and persons in different circumstances may be treated differently, provided that there is a rational basis. So, we can understand that Article 8, Clause 1 prohibits arbitrary and discriminatory exercise of public power through means such as selective prosecution. So, what is selective prosecution? It is when the government is abusing its public power by choosing to enforce the law against this specific individual while deliberately ignoring others who committed the exact same offence in identical circumstances. In the case of Tan Hu Eng and PP, it has been mentioned that the court held that an allegation of selective prosecution must be substantiated by evidence adduced during the trial, because without evidence, it will not result to premature intervention and prejudgment of the case. Applying the law to the present facts, Gagah and Gigih may argue that the sedition prosecution that was initiated for them was made under improper purpose, which constitutes mala fide and also selective prosecution. Why? It is because Gagah merely approached Guguk privately and advised him against engaging in corruption and also cronyism. In addition, Gigih also only posted on social media explaining that Gagah was giving honest and constructive advice. There is no indication that both of them incited violence, promoted hatred, or did anything to overthrow the government. So, more importantly, the prosecution only arose after Guru became angry with Gagah's criticism. Shortly thereafter, both Gagah and Gigih were arrested and charged with sedition. So, this sequence of events suggests that the prosecution may have been motivated by Guru's personal hostility towards them rather than a genuine intention to enforce the law. Following the case of Karpal Singh's, it was mentioned that a power exercise for an ulterior purpose may amount to mala fide. Gagah and Gigih may argue that the sedition law was used to silence them and also protect Guru. Thus, if proven, they may say that mala fide happened and these are the grounds for illegal detention. Moving on, Article 8, Clause 1 prohibits arbitrary and discriminatory exercise of public power. Gagah and Gigih may contend that they were specifically targeted because they criticised Guru. The prosecution, therefore, appears to be based off an improper consideration. This raises a strong allegation of selective prosecution and unequal treatment contrary to Article 8, Clause 1. Gagah and Gigih needs to provide evidence to further support this claim as highlighted in Tan Hu Eng and PP. Moreover, since Gagah and Gigih's criminal prosecution and arrest involve mala fide and also public prosecution, it may be regarded as not in accordance with law under Article 5 Clause 1 and as explained in the case of Ong Ah Chuan. Thus, Gagah and Gigih may argue that their arrest and prosecution are unconstitutional as it violates both Article 5 Clause 1 and also 8 Clause 1. In addition, they may attempt to apply for habeas corpus under 5 Clause 2. Habeas corpus is an order when a person is unlawfully detained asking for release. However, success of the application is uncertain. Based on the principles governing habeas corpus, the remedy is generally unavailable where the detention is resulting from a lawful arrest and criminal charge made under valid law. Nevertheless, Gagah and Gigih have strong grounds to argue that the sedition charges was made under improper purpose to suppress criticism against Guru. This amounts to mala fide and also selective prosecution, which violates Article 8 Clause 1 and results in a deprivation of personal liability otherwise than in accordance with law under Article 5 Clause 1. In such circumstances, the detention could be challenged as unconstitutional and a writ of habeas corpus may be sought. In conclusion, Gagah and Gigih have strong grounds and may argue that the sedition charges brought against them was made under mala fide, which constitute to selective prosecution. Both of these violates Article 8 Clause 1 and in results, the deprivation of personal liability is otherwise than in accordance with Article 5 Clause 1. They also may challenge under Article 5 Clause 2 that their detention is unlawful, thus apply for habeas corpus.
To conclude, Guru's action amount to a serious violation of the Federal Constitution and fundamental liberties guaranteed under it. The declaration of the entire country as a security area and the nationwide curfew appear to have been used to suppress political criticism rather than to address a genuine threat to national security. In doing so, Guru effectively bypassed the constitutional emergency framework under Article 150 and exceeded the proper limits of executive power. In addition, the nationwide curfew restricted the right to peaceful assembly under Article 10 Clause 1 Paragraph B, while the freezing and removal of Gagah and Gigih's social media account interfered with their freedoms of speech and expression under Article 10 Clause 1 Paragraph A. Furthermore, the sedition prosecution raises concerns of mala fide and selective prosecution, which may violate the right guaranteed under Article 5 Clause 1 and 8 Clause 1. Therefore, Gagah and Gigih have strong grounds to challenge the legality and constitutionality of the action taken against them. Ultimately, this case highlights the importance of constitutional supremacy, the rule of law, the judicial oversight in ensuring that executive power remains within its constitutional limits. That's all from us. Thank you.